Good morning and welcome to the January 23rd, 2023 Land Use Hearing Officer meeting. I'm Pamela Jo Hatley and I'll be serving as your hearing officer this morning. Before we get started, please stand as you're able and we'll salute. The United States of America, and to the republic for which it stands, one nation, indivisible, with liberty and justice for all. All right, thank you. Again, I'm Pamela Jo Hatley, and I'll be your hearing officer this morning. First of all, if you have any noise-making devices on you, any computers or cell phones or anything else, please silence those at this time. Now, I would like to introduce Mr. Tom Hisney of the Hillsborough County Development Services Department. Mr. Hisney will introduce staff and any agenda changes, withdrawals, or continuances.
Good morning, Madam Hearing Master. I'm Tom Hisney with Development Services. To my left is Mary Dorman, Senior Assistant County Attorney. To my right is Carmen Mason, Senior Zoning Tech with Development Services. Through the course of the meeting, various planners with Development Services will be making presentations at the podium, and they'll be introduced throughout the course of the meeting. I am now going to read into the record the published withdrawals and continuances from today's hearing. Item A1, Special Use Application 22-1188. The applicant is City Switch 2A LLC. This application is out of order to be heard and is being continued to the February 27th, 2023 Land Use Hearing Officer meeting. Item A2, Special Use Application 22-1361. The applicant is Navigator Academy of Leadership, South Shore. This application has been withdrawn by the applicant. Item A3, Variance Application 22-14-22. The applicant is Mike and Nicole Mesra. This application is out of order to be heard and is being continued to the February 27th, 2023 Land Use Hearing Officer meeting. Item A4, Special Use Application 22-1563. The applicant is Karina Maris Okeek. This application is out of order to be heard and is being continued to the February 27th, 2023 Land Use Hearing Officer meeting. Item A5, Variance Application 22-1585. The applicant is Cadiz Ramirez. This application is out of order to be heard and is being continued to the February 27th, 2023 Land Use Hearing Officer meeting. Item A6, Variance Application 22-1619. The applicant is Emily Janeth Linares Eustace. This application is out of order to be heard and is being continued to the February 27th, 2023 Land Use Hearing Officer meeting. Item A7, Special Use Application 22-1671. Applicant Amber 2 of AP2 Services, LLC. This application is being continued by staff to the February 27th, 2023 Land Use Hearing Officer meeting. And then the last item is A8, Variance Application 22-1672. The applicant is Addie Mentry with Creative Sign Designs. This application is out of order to be heard and is being continued to the February 27th, 2023 Land Use Hearing Officer meeting.
All right. Thank you, Mr. Hisney. Okay, I'll read into the record some procedures for today's meeting. First of all, and again, just a quick reminder, silence any noise-making devices, and thank you for that. The agenda consists of items that require a public hearing by a hearing master. I will conduct a hearing on each item today and will render a decision within 15 working days after the conclusion of today's public hearing. My decision will be filed with the clerk of the Board of County Commissioners. The hearings today will be informal. I will ask questions related to the scope of direct testimony and may call and question witnesses as I deem appropriate. I will decide all questions of procedure. I will take evidence, but will exclude evidence that is irrelevant, immaterial, or unduly repetitious. Evidence may be presented in written form, and all testimony shall be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding of fact unless it would be admissible over objections in a civil court action. The order of presentation today will be as follows. First, for variances, Mr. Hisney will call the case. County Development Services will have 5 minutes to present its report and findings. The applicant and the applicant's witnesses will have 15 minutes to present the proposal. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against a proposal. County staff will have 5 minutes to present any amended findings or comments, and the applicant will have 5 minutes for rebuttal and summation. For special use cases, Mr. Hisney will call the case. Then the applicant and the applicant's witnesses will have 15 minutes to present the proposal. County Development Services will have 5 minutes to present its report and findings. Planning Commission will have 5 minutes to present its finding of compliance or noncompliance with the comprehensive plan. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against the proposal. County staff will have 5 minutes to present any amended findings or comments, and the applicant will have 5 minutes for rebuttal and summation. The 15 minutes that are for proponents and opponents is the total time allotted among the speakers. So if there are a number of persons who wish to speak, the 15 minutes will be distributed among you. You may wish to designate a single spokesperson to represent your views. When you come to the microphone to speak, please first state your name and your address for the record. The meeting is being recorded, so please speak into the microphone so your testimony can be recorded. When you're finished speaking, please see the clerk, to my left over here, the clerk, to sign in for the record. And now we'll hear from the County Attorney's Office, who will state the legal requirements and procedures for appeal.
Mary Dorman from the County Attorney's Office. Am I on now, Tom? There we go. Mary Dorman from the County Attorney's Office. This land use hearing officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed a case, the record of that case is also closed, and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the Appeals Board will only consider the decision of the hearing officer and the record made at this public hearing. If an appeal is filed, the Appeals Board hearing shall consist of oral argument by the party appealing the decision, county staff, and any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the hearing officer or to intervene in an appeal. 1, the applicant, or 2, anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It is the role of the County Attorney's Office to ensure that no new evidence or testimony is allowed before the Appeals Board that was not presented to the hearing officer at today's hearing. The County Attorney will recommend that the Appeals Board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence presented to the Appeals Board that is outside the record created at today's hearing could jeopardize the legality of the Appeals Board decision, and the presenter of that evidence could hurt their own cause. The safest course of action, then, is for you to write down any comments you make today and repeat them to the Appeals Board.
Thank you, Ms. Dorman. All right, all testimony today must be under oath, so if you plan to speak, please stand and raise your hand so I can swear you in. Anyone who wishes to speak today, please stand and raise your hand. All right, thank you. Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I
Thank you.
I do.
All right. Mr. Hisney, we're ready to call the first case, please.
So we have no vested rights cases today, no fee waiver requests, no remands, no reconsideration requests. That'll take us then to section F of the agenda, which are site development variances. First case is item F1, variance 22-1271. The applicant is Stuart Kaufman. They're requesting a variance to encroach into the wetland setback and a variance to fence requirements. Staff findings will be presented by Carla Shelton Knight.
Good morning. Carla Shelton Knight with Development Services. The applicant is requesting variances to accommodate a proposed addition to an existing single-family home and a proposed fence on property zoned PD 78-0017. The variance for the house addition encroachment into the wetland setback per LDC section 4.01.07B4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests a portion of a proposed home addition to be constructed within the 30-foot wetland conservation area setback. The applicant requests a 10.15-foot encroachment into the setback to allow for a remaining setback of 19.85 feet. For the fence height, per LDC section 6.07.02 C1, a maximum fence height of 4 feet is permitted within required front yards in residential zoning districts, except under certain circumstances that do not apply to this case, and a maximum fence height of 6 feet is allowed on the remainder of a parcel. The applicant requests a 4-foot increase to the permitted fence height in the required front yard to allow a height of 8 feet for a proposed fence with metal pickets and masonry columns in the required front yard on the west side of the property, and a 2-foot increase to the permitted fence height outside of the required front yard to allow a height of 8 feet for the proposed fence on a portion of the north and south side property lines as shown on the submitted site plan. Staff findings. The conditions of approval for PD 78-0017 do not include setback requirements for the subject parcel. However, staff has determined the required front yard setback is 25 feet. And Isis Brown with zoning is here to answer any questions regarding the fence, and I can answer any questions regarding the wetland setback encroachment.
All right. Thank you, Ms. Shelton. All right, don't have any questions for Development Services at this time. We'll hear from the applicant.
Chris Caldwell, 912 East Hamilton Avenue, Tampa. I'm the agent on behalf of the Kaufmans, and they are planning the addition to their home via an architect. This all started in early 2021. As they were going through their planning, they realized that the architect realized that most likely would need a wetland delineation to address if there was any wetland issues that had not been on the original plan development plat. So we were hired, we're the environmental engineering consultants. We did the wetland delineation, filed via EPC, and got that approved on the 7th of 2021. The site plan was then kind of redesigned to do the amount of, like the least amount of impacts that they could possibly do on site. This ended up being a calculated total of 140 square feet. The reason that this area was identified as the only feasible place for this addition There's a driveway location and side yard setbacks on the western adjacent property that they did not allow for. There's side yard setbacks from the southern adjacent property. And then this was the furthest distance from the wetland setback line and side yard setbacks that was possible. Another couple things that were restricting additional areas to consider for this addition. There's a current pool and pool cage, which inhibit additions to the eastern rear portion of the residence, which is basically adjacent to where this addition is going to be. And then location of the existing air conditioning handler and pool pump are also in that spot. So the variance request is for that 140 square foot of encroachment into the wetland setback. We did this in mind with the, knowing that there's a compensation plan if you do more than 500 square foot. So we were able to limit it quite a bit to 140 square foot as mentioned. And then in addition to this, there's a fence that they would like to install. There's numerous properties in this neighborhood, as the Avila neighborhood, that have front yard fences. Mr. Kaufman was, concerned of some recent criminal activity in the neighborhood, even if it is all neighborhoods can be subject to this. He mentioned his concerns of some crime that had happened in the neighborhood. There had been some murders which had taken place dating back over the last 10 years. They also were building this extension as a shelter-in-place scenario. Their house has got a big back-facing window facing the water. They're in their 70s, so having somewhere on the first floor was very important to them, to where they can be safe and have their family. So these are the reasons why they're requesting these variances.
Okay. Mr. Caldwell, can you talk about the hardship? And I understand the shape of the lot and the wetland location and the setback, but more about the fence, please. The reasons why the fence needs to be, why the variance is required for the fence based on the hardship.
Yeah, their architecture plan, and it was at the suggestion of the development services, was for a 6-foot fence. The actual masonry bits are 6 foot. The actual fence is 8 feet. It's a metal, kind of spike, exactly the full design, but essentially you have your masonry stations, and then your panels are the thin metal tipped rods. So that's where you're getting your 8 feet. It was, mostly it's a safety concern for them. They want to protect their property. They've had some, essentially they've had robberies and crime that was enough to where, they figured it would be a good idea to add something to their property for that protection. Currently, they don't have any fence on their property. And essentially it was just out of safety for their, life and property.
Is it, this community a gated community?
It is a gated community.
Okay, thank you. Okay. Anything additional you wish to?
Not at this moment.
All right. Thank you so much. Okay. So is there anyone in the room, or do we have an online component to this meeting?
Yes, ma'am.
Okay. So we should ask then, is there any member of the public here or online who wishes to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application?
Good morning, Madam Land Use Hearing Officer and members of the board. My name is Scott Stigl. My address is 601 Bayshore Boulevard, Suite 700, Tampa, Florida, 33606. I'm an attorney with the Gunster Law Firm, and I'm here representing Arnold and Lauren Bellini, who live at 802 Torre de Avila, which is the neighbors to the petitioner, Stuart and Debbie Kaufman. We're not here because we're not good neighbors. I think everybody's friendly, and we don't have any issues with each other. Personally, however, there are concerns with this particular request. Just to let the board know, Mr. Bellini, Arnold Bellini, is here with me today. And the biggest issue we have here is concerns over the wetland encroachment. We have a situation here where they're seeking to encroach 10 feet into a 30-foot setback on the wetlands, 140-foot square 140 square foot overall encroachment. That's about a third of the way into the protected mandatory setbacks into this wetland. It's going to adversely impact the natural habitat, basically the wildlife neighbors that we have in this area here. This is a wildlife refuge. The clients, the Bellinis, have seen actual Florida panthers in this area. We've seen eagles, cranes, woodpeckers, another endangered species. We've also seen deer, alligators, owls, and woodpeckers. Further encroachment into this area would endanger these habitats which the wetlands setbacks are set to protect. Also, by increasing further into this wetland setback, you're increasing the likelihood of potential fertilized runoff into the lake, which runs right beside this the 30-foot setback. They're already encroaching currently into the wetlands. I have provided some photographs with my prior written submission to the board, and I have some additional, a photo that if anybody needs additional copies of I have, but I wanted to go ahead and show this on the.
And Mr. Stigl, could you clarify, please, do you mean that there are currently encroachments in the wetland itself or the wetland conservation area setback?
Into the setback, Your Honor, right here, you'll see there's already a putting green that's been installed. And again, this is to my understanding that putting green actually is within the 30-foot setback already. I believe there's a line that runs about through here where there's a cutoff and it actually encroaches into that setback currently. So we believe further encroachment obviously is dangerous and a bad precedent to set in allowing the people to go into this wetland. In terms of the Bellinis themselves, it would block their view of Lake Chapman. Obviously, a blocking of that view would reduce property values. Again, there's no real issues here with the Kaufmans themselves, but with the protection of the natural habitat that needs to be protected, which is the reason why we have this 30-foot setback in the first place. I mean, there's a reason for it. It's not just something or a suggestion. It's actually there to protect the wetlands, which obviously Florida finds to be a very important thing to protect, and I believe we should continue to protect those wetlands. As to the fence itself, I think some questions have already kind of raised this issue. We believe that an 8-foot high fence is an extreme request, given the central location of the property in the neighborhood. To my understanding, unless someone can inform me otherwise, I don't believe there are any other 8-foot fences in the neighborhood. And we're seeking, a front fence that's at least 2 times the size allowed by LDC section 6.07.02-C1. In effect, they're creating a compound in a pretty nice neighborhood that, as has already been indicated, is both gated and, as I understand, there's guards. So to the extent that there's potential criminal activity, I'm not sure that justifies such an extreme request in terms of the height of the fence. And the final point I would make is that the Kaufmans realized when they built this home or they moved into this neighborhood that they were building into this or moving into a neighborhood with a 30-foot natural preserve. And all the neighbors enjoy that same protection of that natural preserve, and they all buy there to have that preserve and to have this natural habitat behind them. They now want to kind of ignore that or just kind of seek some special privileges to build a home further into that when they knew that when they built there and lived there that this is protected for everybody, including themselves, and that should not be allowed to be breached for a home. It's my understanding there's a driveway possibly on one side. There's also a pool fence and everything else. I understand that those kind of prevent some other expansion there, but in lieu of protecting the wetlands, which are a heavy priority of the state of Florida, maybe someone could do without a little bit of a pool or a driveway. So we would request that this application be denied.
All right, just a couple of things that you said, Mr. Stigl. I had questions about, you mentioned a wildlife refuge. Is there any formal designation of this area as a wildlife refuge, or is it just that your clients have seen particular wildlife species in this area?
Your Honor, can Mr. Bellini answer some of these questions?
Please come to the microphone and state your name and your address. Thank you.
Sure. Arnie Bellini, 802 Torre de Avila, Tampa, Florida, 33618. So no, it is not an official wildlife refuge. It is, however, a place where 5 endangered species currently reside. And so I just wanted to say a couple things. We love the Kaufmans. We're good neighbors. We're looking forward to them building whatever they want to build within the current code, within the current setbacks. It not only affects our view, it affects the nature around us. And, you know, I know the gentleman earlier mentioned that there were several murders in the neighborhood, and it's sad to say that those were all inside jobs. So guards and fences aren't going to fix that problem. And so it's not a really high crime neighborhood. It has guards, it has high walls all around the neighborhood. I don't want to prevent them from doing what they want to do, but I also don't want to have a lower property value as a result of it. I also don't want to see any more encroachment into the wetlands area. And just quick anecdotal story, my wife and I saw a Florida panther 2-3 years in a row back there, and it inspired us to then lead a mission to create the Florida Wildlife Corridor Act, which was passed in 2021, primarily and largely due to our family's involvement. So to me, it would just be a crush of spirit to watch more of that wetlands be encroached when we spent so much of our money and time and effort trying to do good things for the state of Florida. That being said, we want the Kaufmans to do whatever they're allowed to do within the zoning, and we cheer that on and are wonderful neighbors with them. Thank you.
Mr. Bellini, thank you. How long have you owned your property there?
23 years.
And you've resided there
Yes,
during
ma'am.
that time?
Yeah, it's
Okay.
our primary residence. We've raised our whole family there, yeah.
Okay, thank you. And then just one more question about an issue that Mr. Stigl raised, and either one of you could answer this, but is there an assertion of any right to a view, as in riparian rights or other right to a view, because you mentioned that it would block the view?
There is no easement, if that's what you're getting at. There's no legal, there's nothing legally binding that at all. No,
Okay.
it's not, not at all, no.
Okay, thank you. That's all the questions I have for you.
Okay.
Thank you. Don't forget to sign in with the clerk, please. All right, is there anyone else here or online who wishes to speak in opposition to this application? All right, don't hear anyone. Development Services, anything further?
No, ma'am.
All right. Applicant, you have 5 minutes for rebuttal or summation.
In regards to the encroachment to wetlands, yes, that is there's a standard in this county, 30-foot setback, to protect, numerous issues from flooding to protection of actual animals, flora and fauna on the site. Those setbacks are designated to help, basically create a buffer between these areas. Currently in that buffer, and from our knowledge of looking at aerials dating back to when this house was built, in 93, I believe, there was no conservation easement established on this property at any time in our record history until they hired an architect to build this extension. This extension, because the architect that they're using, contacted us to say, hey, we want to just make sure that we're not going to run into any issues with this wetland. So that's why we were hired to do an actual wetland delineation. And that was verified on December 7th of 21. So, to their knowledge, to the architect's knowledge, and to our knowledge prior to being on site, there was no buffer other than, there's an official buffer. There's not an official wetland line on this property until it was established via EPC. Obviously there's a wetland there. We can see it from the aerials. We can see it from on site. And, they were doing basically their due diligence to protect this as much as possible. 140 feet is, and it does sound like it's a little bit of an area. It's essentially an area that has been dominated by St. Augustine grass, and there is no trees in this area of proposed encroachment. So whatever protections there are now for the wetland are, in the eyes of environmental scientists, which is what my title is, it's not offering any natural buffer protection or anything really to benefit this wetland than current. So the encroachment, yes, is part of this process, and that's why we're here, obviously. And then, let me just see.
Mr. Caldwell, are you aware of any dedications on the plat or anything about this wetland area?
No, there was nothing that we saw in the plat.
Okay.
There wasn't anything there. Because we typically, when we look at these things, we make sure there's something established before we could, start our work from. And then when it comes to the fence area, I know he mentioned this is a central part of this, of this neighborhood. This property is located at the end of a cul-de-sac. The only people that are really, I think there's 4 houses that are on this cul-de-sac. I understand the 8-foot, I want to reiterate the 8-foot fence is not it's not a brick wall 8-foot fence. It is a kind of a step on and off. So
Okay.
there are fences in the neighborhood that on people's properties. So this one is, I think well within other standards on site. So yeah, that's all I have for now.
All right, thank you. Okay, that will close the hearing then on variance 22-1271.
Our next case is item F2, variance application 22-1530. The applicant is Louisa Alonso. They are requesting a variance to encroach into the wetland setback. Staff findings will be presented by Carla Shelton Knight.
Good morning. For variance 22-1530, the applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on November 17th, 2022, is to allow for the already constructed paver area and 6-foot tall privacy fence to remain within the 30-foot wetland conservation area setback. The summary of the variance per LDC section 4.01.07B4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests after-the-fact approval for the construction of a paver area and a 6-foot high PVC privacy fence within the 30-foot wetland conservation area setback. The applicant requests a 24.5-foot encroachment into the setback to allow for a remaining setback of 5.5 feet. Staff findings. A wetland setback compensation planting plan has been provided on the site plan dated December 13th, 2022, that provides compensation planting equivalent to 50% of the square footage of the amount of encroachment. This site has a limited area of remaining wetland setback area for planting. A portion of the yard area outside of the wetland setback area will be utilized for compensation planting. Natural Resources has approved this planting plan. Finding number 2, a notice of violation, code enforcement case CE 227556, has been issued by Hillsborough County for unpermitted activity in a wetland setback for this property. Approval of this variance request will resolve the outstanding enforcement issue. That's all from staff.
All right, thank you, Ms. Shelton. All right, applicant.
Good morning, John Saldana with Rojo Architecture, 5701 East Hillsborough, Tampa, Florida, 33610. Here on behalf of Mr. Ruiz and Ms. Alonso. I do have an affidavit that was updated last week allowing me to speak on their behalf. I don't know if I need to enter it into the record.
Yes, please.
And the staff commented, this is correct, this is an after construction variance request. The owner purchased the property in 2022. And the variance criteria response is very specific on the request. I'll just go through some highlights. The subject property is in pink, and part of the owner's hardship is the fact that he moved into a neighborhood where very few properties are impacted by a wetland. There's no neighbors to that portion of the property. And so when they purchased the property, in which most homes already have privacy fences and back decks and pavers, they just thought, well, they're planning to put a pool in the back of the house, but they decided they wanted to go ahead and fence their property and level off that portion of the site, mainly for safety concerns. They have a 2-year-old child and a new baby-born girl, and they had heard anecdotes from some neighbors that there was some gator activity. So again, pretty quickly after they purchased the property, they just seeked out to paver part of their backyard and provide a privacy fence, not knowing that they were encroaching on a wetland setback, just the setback portion of it. The original survey they got with the property, and we're talking the wetland setback is to this portion of it, was not depicted on the site plan. So again, when they got their paving and fence built, they didn't think they would require a permit because that's what they had seen in the neighborhood. And that's why they went ahead and built the structures. The subject fence and pavers are to the east, as I mentioned, to this portion right here. And the approval of this variance will not interfere with any other right or any other property in the neighborhood. The fence and the pavers do not cross the wetland line. And luckily, the pavers were installed on compacted fill and sand, so they do permeate through them. Upon receiving the violation notice, they immediately started the process to rectify this, again, not knowing that they had crossed the line they shouldn't have. He hired a professional to help with this variance and submitted all paperwork requested. In doing so, it was found that there are several wetland setback variances already approved within the same neighborhood, and 3 of them in particular were for a home addition, a new home construction, and a lanai structure, out of which, in their mind, they are not providing any of these types of scope of work. It's just, again, pavers on sand and a 6-foot privacy fence. And they are asking for your approval of this variance so they cannot, which will result in just overall safety and comfort to their family. I can address any specific questions, but that's sort of the highlights.
Okay, just a couple. First of all, you mentioned there are other wetland setback variances approved in this neighborhood. Do those apply to the same wetland area?
They are different wetland areas,
Okay.
but they're all within a quarter mile.
Okay, so somewhere within a quarter mile of this property.
Correct, all 3. It appears all 3 of them, based on the report.
Okay. All right, that's all the questions I have for you right now, sir. Thank you. Be sure and sign in with the clerk. All right, is there anyone here or online who wishes to speak in support of this application? All right, do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? There is someone online, or there's no one online? Is that what I heard?
No, no one online.
Thank you. All right, Development Services, do you have anything further? Okay. And applicant, you actually do have 5 minutes for rebuttal or summation. Did you have anything further you wish to add?
No, just thank you for your time and consideration.
All right,
Thank you.
thank you. All right, at this time, we're going to take just a 5-minute quick comfort break. So we'll reconvene in just about 5 minutes. Thank you.
I was gonna close the PowerPoint, but we do have one PowerPoint coming up, so I'll leave it up.
All right, thank you very much. We'll reconvene. This is the January 23rd, 2023 Land Use Hearing Officer meeting. And I believe we're ready to call the next case.
The last case concluded Section F of the agenda. We have no signed variances today, so that will take us to Section H, which are the general variances. First case is item H1, application 22-1528. The applicant is Pastor Rodney Bandy. The request is for a variance to buffering and screening requirements between land uses and also a variance to buffering and screening requirements for off-street vehicular use areas. Staff findings will be presented by Sam Ball.
Good morning, Sam Ball of Development Services. The applicant is requesting two variances. One's to require buffering and screening and the off-street vehicle use buffers on properties owned RMC 16 in order to accommodate the development of a proposed 117-seat church. For the first variance, section 60606A requires that the proposed church must provide a 10-foot wide buffer with type A screening along the northern and southern boundaries of the project site due to the adjacent multifamily residential developments. The applicant requests a 5-foot decrease to the minimum required buffer width to allow a 5-foot wide buffer along the northern and southern boundaries. I'd like to note that no variance is requested to the type A screening requirement in those buffers. The second variance is from the requirements of LDC section 60604E1, which requires that the landscape buffer, a minimum of 6 feet in width, shall be required between the off-street vehicular use area and any property boundary not fronted by road right-of-way, unless the buffer or screening requirement of 60606 and 60606C are more stringent, in which case the more stringent requirement shall apply. The applicant is requesting a 1-foot decrease to the minimum required buffer width to allow the 5-foot width for the vehicular use area buffer where required along the northern and southern boundaries. I'd also like to add that the applicant originally requested a variance to the minimum width required for drive aisles in the project, but is no longer seeking that variance because any variances that are to that section are handled administratively by the Transportation Department and not under the Land Use Hearing Officer process. That concludes my presentation.
All right. Thank you, Mr. Ball.
And thank you.
All right, applicant.
Hello, my name is Pastor Rodney Bandy at the address P.O. Box 16751, Tampa, Florida 33687, Miracle Faith and Deliverance Church.
All right. Yes, sir.
I'm William Butney at 1890 Curlew Road, Dunedin, Florida.
Okay. Thank you. And who will present, either of you will present the variance request and the hardship basis for the variance?
We are proposing building a church on 14th Street, and as the staff suggested, we're requesting a variance relief from the buffer from, as I understand it, on the side property lines. It was required 6 feet, and we were requesting that be 5 feet. The other variance was adjacent to the building itself. I think a buffer was required, and due to the width of the drive aisle and the walkway required next to the building, doesn't allow a buffer area to be included. And the restriction is based on the width of the building and the actual width of the property. It's kind of constrained us in that there wasn't an opportunity to buy more property. So that's the issue that we're up against.
Okay. All right. So to be clear, the staff report states that the proposed church, this use, is required to provide a 10-foot wide buffer with type A screening on the northern and southern boundaries, and that's because it's adjacent to a different type of use, and that's multifamily residential use. So you're requesting then on the northern and southern boundaries of this property, you're requesting to reduce that 10-foot wide buffer to 5 feet. Is that correct?
That's correct.
On both.
Yes.
And
Thank you for clarifying.
is it your testimony then that the reason, the basis for that variance request is because the property, the size of the property won't accommodate the development without that reduction in the
Yes, ma'am.
buffer?
Yes, you're right.
Okay. And there's no request for a variance from the required screening. Do you plan to put fencing or something along those boundaries?
Yes, the plan is to install a 6-foot PVC fence on the 3 sides of the property.
Okay. All right, and then the other variance is, staff report states that a buffer, a minimum of 6 feet in width is required between the off-street vehicle use areas and the property boundaries that are not fronted by a road right-of-way. So again, your request is for a 1-foot reduction in that buffer to allow a 5-foot width for that buffer. And again, is that correct?
That's correct.
Okay. And the reason, the basis for that request is, again, the size of the property won't accommodate your development without a reduction in that buffer area. Is that correct? Okay. And I see your site plan is in the record. All right. Any additional information you wish to provide?
Yes, I just want to say that the whole entire project is to benefit the community. I'm very, I guess, involved in the community. We've probably given out over $100,000 worth of goods from Walmart. We partner with Publix. I've also partnered with the school, where it's at a 93% poverty level for the children. So I'm very excited about the project, and if the community now is benefiting just from our presence, they're excited about it. So I just wanted to mention that we're very excited about that community.
All right, thank you for that. And just to be clear, your plan is to construct a church building there, is that correct?
Yes.
Okay, thank you. All right, that's all the questions I have for you. Please be sure and sign in with the clerk. All right, is there anyone here or online who wishes to speak in support of this application? All right, I don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this variance request?
No one online.
Okay. Do not hear anyone. Development Services, anything further?
No, ma'am.
All right, thank you. Applicant, one more time, anything further you wish to state or submit to the record? No, okay, that's a no. All right, thank you. That will conclude the hearing on variance 22-1528.
Our next case is item H2, variance application 22-1600. The applicant is Jenny Portes. The request is for a variance to lot development standards. Staff findings will be presented by Sam Ball.
Hey, good morning, Sam Ball with Development Services. The applicant is requesting a setback variance to accommodate an existing carport attached to a single-family dwelling on property zoned RSC 6. The subject parcel is a corner lot with frontage on 2 roads, therefore it is required to have required front yards along both road frontages and required side yards along interior lot lines. According to LDC section 60101, a minimum front yard setback of 25 feet is required in the RSC 6 district. The applicant requests a 5-foot decrease to the required front yard setback to allow a 20-foot setback for the carport from the southeasterly property line on Florida Drive. Findings are the code enforcement citation, HCCMP 22-000091 for failure to obtain a building permit for the carport was issued on February 23rd, 2022. The applicant submitted an after-fact building permit application HC BLD 22-0037481 for the carport. The site plan included with the application for the building permit shows the carport setback 21 feet 2 inches from the southeasterly property line. According to the applicant, the aluminum shed shown on the southwestern property line that is shown on the site plan submitted for the variance request has been removed from the property, and variance 080717 was approved in 2008 to allow a 3-foot setback for the 2-story accessory structure shown on the site plan in the functional rear yard of the subject property. That concludes my report. Thank you.
Okay, thank you, Mr. Ball. All right, applicant?
On the 10th.
Is the applicant here or online? This is variance 22-1600.
No one's online.
All right.
If you'd care to defer this case to later in the agenda, we'll reach out to the applicant's representative to see if they're available.
Okay. All right, that's what we'll do then. So variance 22-1600. We don't hear the applicant here, so we will defer this one to later in the hearing today, and meanwhile, we'll try to contact the applicant. So ready for the next.
All right, next case is item H3, variance application 22-1632. The applicant is Jason Brust, requesting a variance to swimming pool requirements. Staff findings will be presented by Chris Grangillard.
Good morning.
Morning.
Chris Grandlinar, planner with Development Services. I'm here to present variance 22-1632. The applicant is requesting a front setback variance to accommodate a proposed attached pool and screen enclosure without a solid roof on a corner lot zoned RSC 6. Per LDC section 611.94.B.1, a swimming pool enclosed by a screen mesh structure without a solid roof that is attached to the primary building may not intrude into the required front yard setback, except under certain circumstances that do not apply in this case. Per LDC section 6.01.01, a minimum front yard setback of 25 feet is required in the RSC 6 district. The subject parcel is a corner lot with required front yards on the south and east sides. The applicant requests a 20-foot reduction to the required front yard setback to allow a setback of 5 feet from the east property line along Krenzler Avenue, which functions as a side yard. Per LDC section 601.06, minimum lot size of 1/2 acre of upland is required for the use of a septic system. The subject property is served by a septic and is 0.41 acres in size approximately. Therefore, it is non-conforming. However, it has been certified as a legal non-conforming lot per NCL application 22-1722 that has been placed in the case record. That concludes my staff report for variance 22-1632. I'm glad to answer any questions you may have.
Just one, Mr. Grandlinar, is this variance request for a new pool, or is there an existing pool and it's just for the screen mesh structure?
I believe it's a new pool. I'm sure the applicant will be able to go further on that.
Thank you. I'll have the applicant clarify that. Thank you. All right, we'll hear from the applicant now.
Good morning, board.
Good morning.
Can you hear me?
Yes.
All right, perfect. Yes, like the,
And before you start, we need your name and address, please.
okay, my name's Jason Brust, B-R-U-S-T. Address is 17033 Badowski Road, Brooksville, Florida, 34614.
Okay.
Okay, yeah, so thank you. Thank you for your time. I'm requesting the change in the east front yard setback from 25 to 5 feet. It is a new pool, in fact, new pool construction. Talking with the builder, the septic tank, it was in the rear of the house. That's why they decided to put the pool on the side. Now, on the survey for the swimming pool, it clearly states that screen was going to be the barrier for the pool safety to protect it. And then, so to have a total transparent conversation here, there's the septic system is in the backyard, but the pool cage is already built. And so I've already informed the homeowner, there's a possibility I may have to take it down. We would not like to, it's not ideal. He would like if we're keeping his pool clean and stuff like that. It doesn't look intrusive. It's inside his privacy fence, but we do need the setback approved to be able to permit it and close it out.
All right, thank you, sir. I mean, it looks like on the aerial that there's an existing pool, so is the pool built as well?
The swimming pool is built, yes, ma'am, and has water in it.
Okay, so the swimming pool was built and the cage was built, but no permits were pulled for it?
Permits were pulled for the pool,
Okay,
not for the cage. I assumed we had it. We did not. The cage got built. I asked my assistant to final it out, and then that's when she discovered the email about it was in the variance that the pool never should have been there.
okay, I see. Okay. And then could you just address the hardship criteria for the variance, please?
Okay, so the hardship is that even though it is a non-conforming lot with the septic tank, the septic was in the rear. That's how the pool builder, because original plan was pool in the rear of the home. Pool builder found the septic system, they moved it to the side, and it was strictly my negligence that I did not realize we didn't have our permit in hand. The pool builder had gotten their permit, all their inspections, and the same survey that we turned in to the building department with our application is the same survey. We got that from the pool builder, and it did say screen for the protective barrier. So,
Okay, I see. All right, anything else you wish to put into the record?
you guys have a copy of the survey already. I have it here with me to put on this machine if you guys need to see it where it states that, but I'm at your guys' mercy. Me and Mr. Flores he would like to keep the pool, hopefully the cage. Hopefully you guys see fit, and if not, we'll cross that bridge, you know?
There is a copy of it in the record, but if you wouldn't mind, put it on the screen, please, and just let me see it and see if there's any differences or if I have any questions pop into my head after seeing that.
Yes, ma'am.
Thank you. Could you show me the shed that, I think it was this the one that a shed had been removed? Or am I thinking of the prior one?
It's still in place, and it's actually closer to the property line.
Please speak on the microphone.
Yes, ma'am. The shed is,
Oh, I think I'm thinking of a different application.
no, this is the one.
Never
It
mind.
is, the shed is here. It has not been removed yet.
Okay.
And it is closer to the property line than the pool cage.
Okay. And what's going to happen with that one? Anything going to happen with that shed?
Not sure, nothing in my plans. I mean,
Okay.
if you guys say something to the homeowner, if he gets his variance, I'm assuming it's going to be okay. I'm
Okay.
not sure.
All right. So, yep, this shows the pool and then the pool cage around it. That's the, as shown on the site plan, and
Right, and
that's it.
then down here at the bottom, this is what was turned in,
Okay.
and you can see
Yes.
barrier for the screen. Don't know how to find it in your light there. There you go.
All right, that's fine. It's in the record.
Yes, ma'am.
Okay. All right, thank you, sir. Anything further?
No.
All right.
Hopefully it goes well.
All right. Be sure and sign in with the clerk here.
Yes, ma'am. Thank you for your time.
You're welcome. All right, is there anyone here or online who wishes to speak in support of this application?
No one online.
All right, thank you. Is there anyone here or online who wishes to speak in opposition to this application? Don't hear anyone? Okay. Development Services, anything further?
No, ma'am.
All right, thank you. Anything further, applicant? No, okay, thank you. That will close the hearing on variance 22-1632.
Our next, our next case is item H4, variance application 22-1666. Applicant is Brad Algren, requesting a variance to lot development standard. Staff findings will be presented by Tim Lampkin.
Good morning, Tim Lampkin. The applicant is requesting a height variance for a proposed single-family house on a property that's zoned PD 91-0150. Per LDC section 6.01.01, a maximum building height of 35 feet is allowed. The applicant requests a 9-foot increase to the maximum permitted height to allow a height of 44 feet as measured from the base flood elevation. Staff finds that the parcel is mapped within the special flood zoned area, flood zone AE, with a current effective base flood elevation of 9 feet. The Land Development Code defines height as, quote, the vertical distance measured from the lowest proposed finished grade of the structure vertically beneath the highest point of the structure. Elevated structures within the designated special flood hazard area will have the vertical elevation measured from the base flood elevation to the highest point of the structure. Finished grade shall be determined using all applicable regulations of the county, state, and federal regulations. The applicant's architectural renderings submitted shows the proposed house will have a height of 41 feet and 4 inches as measured from base flood elevation. And that concludes staff's presentation, unless you have any questions.
Don't have any questions for you. Thank you.
Thank you. And I do believe the applicant is going to be online because they're out of town.
Okay. All right, we'll hear from the applicant.
Good morning. My name is Brad Algren. I'm at 6432 Lake Sunrise Drive, Apollo Beach, Florida, 33572. Thank you for allowing me to appear and speak virtually. And my wife and I are the owners of the property in question. We're considering building a home on the property and had plans designed and drawn up that are keeping with the neighborhood and the location on the Little Manatee River. And simply put, to reasonably address current flood events like Hurricane Ian with a 15-foot surge, we have proposed a design that has an overall height that exceeds that 35 above base flood elevation. And therefore, we'd like to request a variance to accommodate that. And I have to admit that at the beginning, I was a little confused with all the different terms, the base flood, finished floor elevation. But to simplify things, the home that we have in question is about 6 feet above that 35-foot maximum, and we're requesting 9 just to accommodate a few issues that could come up with the builder. So therefore, we're asking for this variance, and we thank you and be willing to answer any questions.
Okay, yes, so just to be clear then, your proposed home, as I understand it, has to be built up because of the base flood elevation. And then the home itself isn't that tall. It's just because it's built up off the ground elevation. Is that correct, basically?
Yeah, to to simplify things, I guess I would prefer to go back to what we'd call zero, or I believe it's mean low water, call that zero. And so the county requires any finished floor to start at 9 feet and above. I want to have my finished floor start at about 15 or above and then go from there. So, you know, there's a difference of 6 feet, which would be, you know, middle of the garage. From that point up is where they measure.
I see.
And overall, I'm at 50 feet. You know, subtract that 9 feet for the base flood, and we're at 41 feet right now.
Okay.
Instead of the
okay.
35 that they request.
All right, thank you. I understand now. Thank you for clarifying that. All right, anything else you wish to add?
Oh, I believe in the record there's already pictures of the neighboring home. There's nobody on my east. There's a large mansion, if you remember Land Manor, and that's about at 50 feet right now. So I don't believe I'm asking anything unusual, but that's all in the record in your document database.
Okay, thank you. All right, we'll go to the public then. Is there anyone here or online who wishes to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, I don't hear
I
anyone.
think there.
James Anthony Hudson, 2420 West Shell Point Road, in support of the request. Am I being heard?
All right, one moment. I believe we need your video, and could you state that again, please? Thank you.
Can you hear me?
I can hear you, but you're breaking up.
Good. My name's Anthony Hudson, 2420 West Shell Point Road, on the second house, or the second lot west of the proposed property, and I'm speaking in support of Mr. Algren's request. I don't have anything substantive to add, that my property is elevation, and the finish height is approximately the same. I couldn't give the exact numbers, but very similar.
All right, sir. Are you speaking in opposition or support?
In support of, ma'am. In support of.
And you're breaking up a little bit. Did you say support? All right, try it one more time, please. Mr. Hudson, can you try it one more time, please, sir?
Yes, ma'am. I speak in support of Mr. Algren's request.
Okay, wonderful. Thank you so much. I understand. All right, anything else you wish to add? Okay. Is there anyone else here or online who wishes to speak in support or in opposition to this application? All right, don't hear anyone. Development Services, anything further?
No, ma'am.
Thank you. Applicant, anything further?
No, thank you for your time.
All right, yes, sir, thank you. This closes the hearing on variance 22-1666.
Our next case is item H5, variance application 22-1669. The applicant is Craig Tariski and Brian Dion. The request is a variance to accessory structure requirements. Staff findings will be presented by Isis Brown.
Good morning, Isis Brown, Development Services, variance 22-1669. The applicant is requesting variances to accommodate a proposed detached garage that will be greater than 15 feet in height on a property zoned RSC 6. Per LDC Section 611.04B, accessory structures shall not exceed 15 feet in height except where they meet primary structure setbacks in that zoning district. Per LDC Section 6.06.01, a minimum rear yard setback of 25 feet is required in the RSC 6 zoning district. The requests are as follows. An 8.7-foot reduction to the required minimum rear yard setback to allow a rear yard setback of 16.3 feet from the west property line. And the second variance, a 1-foot 7-inch increase to the permitted maximum structure height to allow a height of 16 feet and 7.5 inches. Staff findings, per LDC Section 6.0106, a minimum lot size of 1/2 acre of upland is required for septic system. The subject site is served by septic system, but only 0.39 acres in size. There is a therefore non-conforming. However, NCL 23-0010 has been placed on record, and the lot has been deemed approved non-conforming. I'm available for any questions.
All right. Thank you, Ms. Brown.
Okay.
All right, applicant?
Good morning. Brian Dion from Johnson Pope, 490 First Street South, St. Petersburg, Florida. I do have a presentation to go through. Again, this is for variance number 22-1669. I represent Robert and Victoria Horvath, who are also present, if you have any questions for them. I also have present the contractor who is erecting, or who is scheduled to erect, the accessory structure that we are asking for the variance for today. Some information on the site. The address is 1810 Green Lawn Street, Brandon, Florida. As mentioned by staff, the site is approximately 0.39 acres and is zoned in RSC 6. It's located in the urban service area. It is a platted property. It was platted approximately 1973. This is the site. This is Lot 9, Block 4 of the Oakmont Manor Unit Number 2 plat. As mentioned, the site is legally non-conforming. We have a letter certifying that it is legally non-conforming from the county. And this is, on the left, is the deed that existed in 1989 of the property. On the right is the property owner's deed. The legal descriptions are the same. Accessory structures shall, per LDC 6.11.04.b, accessory structures shall not exceed 15 feet in height, except when the accessory structure meets the primary structure setback of the district, in which case the maximum height of the accessory structure may be that of the district. Item number 2 doesn't really matter here. It's on the agricultural structure. But to clarify a point from staff, we are asking for a structure over 15 feet, so therefore it'd have to be within the zoning setbacks, which in this case, really the one that matters is the rear setback of 25 feet. We're asking for a structure that is 16 feet, 7.5 inches to be within that rear setback. Per the code, the maximum height is allowed to be 35 feet. Again, the structure is 16 feet, 7.5 inches. It's a 60 square foot structure. It's prefabricated and detached from, the primary structure. It's a garage. This is an example of what it looks like. This is not the actual structure. It also will be raised on a concrete slab as well. Reason for the request, as I mentioned, the height of the structure is 6 feet, 7.5 inches, and it will be It's 16.3 feet within the rear setback line with a 25-foot requirement, so that's 8.75 feet within the setback area. Accessory structures up to 15 feet in height are allowed by right with a minimum setback of only 3 feet from the rear property line, but the proposed garage exceeds such height by 1 foot, 7.5 inches. So if the structure was 15 feet or less, it would be allowed to be within 3 feet of the rear and side yard setback. This is the single-family home that's owned by my client. These are two pictures of the backyard. The first one is facing rear towards that corner, which I will emphasize in a moment, and then the second one is facing on the west property line, approximately where the structure will be located. Here is the site plan of the site. This is a zoomed-in version of the site plan. As you can see, the single-family home is pretty much in the middle of the site, off the setbacks, and it leaves, because of the unique structure siting of the plat or the plot, it makes it difficult to be able to place structures, adjacent to property lines, or really that corner, avoiding that corner, and really the dead space that's in there because of the setback. This is a zoomed-in picture of the garage from the site plan. Again, you can see the garage towards the southwestern side of the property. The 25-foot setback line is shown in blue. The entire area of the garage that will be within the setback is in the green, and then the red is the portion of the structure that is over 15 feet that's within the setback, which, as you can see, it's pretty minimal as far as what's going to be within the setback area that is non-compliant. This is the elevations for the building. It shows the 15 feet line and then the 16 feet, 7.5 inch line as well. Variances, as you are probably more aware than I am, they shall be granted if they are not for issues such as floor area ratio, land use density. Again, this is a structure being within the setback. And what we would like to show is the practical difficulties and unnecessary hardships that are shown through the to allow you to grant us this variance request. There are 6 criteria that are provided by the code. The first one is that the alleged hardship or practical difficulties are unique and singular as regards the property of the person requesting the variance and are not those suffered in common with other properties similarly located. Again, I do want to emphasize the shape of the yard, the property, and the location of the yard as it is with the primary structure on the property. That creates a hardship because of the unique shape and the ability to even have an accessory structure in the yard. The primary structure, as you can see here, faces the street, the front of the property, and therefore is angled in a way that minimizes the back yard and the rear and infringes or creates any accessory structure to have difficulty with not infringing upon the setbacks. Impact setbacks when compared to more typical rectangular lots. As you saw in the plat, most lots in this plat were rectangular, and the surrounding properties of other plats that are directly adjacent to this plat are largely triangular as well. And then also the prefabricated garage itself. Because it's prefabricated, there are certain heights needed for certain square footage, so that makes it difficult for us to be able to obtain one that would be both the size that we need and under those height regulations. Again, this is the site's variance criteria 2, that literal interpretation of the provisions of this code would deprive the applicant of rights commonly enjoyed by other properties in the same district and area under the terms of the code. Again, I'm going to refer to the triangular geometry of the property and the acute angles that are created by the sharp angles on the side, which, again, here's a picture of the property where they meet in the back, creating an area in the setback that would be impossible to build anything within. the literal interpretation inordinately restricts the reasonable use of the applicant's rear yard. And then in the adjacent areas, as I mentioned, there are accessory structures that are shown here that are close to, that are large in size, that are on brand with what we're trying to do here as far as distance from setbacks, from yard lines, and in size. Here, I think there's 16 in the immediate vicinity of our client's property. Criteria number 3, that the variance, if allowed, will not substantially interfere with or injure the rights of others whose property would be affected by allowance of the variance. Here I want to focus on the minimal height request change. It's 1.5 feet. It's a little over 1.5 feet that we're asking for. Accessory structures, again, by right, are allowed to be within 3 feet of the property line if they're just 1.5 feet shorter than what we're asking for. Only a minimal portion of the garage that exceeds that height will be within the setback area. As I've shown here, it's that red triangle, not even the green triangle, it's the smaller red triangle, which is a fraction of the garage. The rear yard is enclosed by a 6-foot tall opaque fence, and there are also trees in certain sections of the rear yard that would help mitigate any sort of impacts on adjacent properties. And it's our belief and understanding that the impacts that we're proposing here at 16.3 feet away from the property line is less of an impact than a 15-foot structure at 3 feet. Criteria 4, that the variance is in harmony with and serves the general intent and purpose of the code and the comprehensive plan. Really quickly, the comprehensive plan allows for or promotes property owners to develop and improve their property. The LDC also states that in A 102.03A, the intent of the LDC is to provide for equitable terms consistent with the established regulations, procedures, and respect for the rights of the property owners. Further, the board wants to promote property owners that have good planning, good designs. Again, this is a prefabricated, it's a well-designed structure that will be on a concrete slab that will also be painted the same color as the house so that they are fluid together. The requested variance serves the applicant by allowing enjoyment of the property in a way that is commonly enjoyed by others within the same district. And the garage's location promotes the reasonable functionality of good planning and design practices. Variance criteria 5, that the situation sought to be relieved by the variance does not result from an illegal act or results from the actions of the applicant resulting in self-imposed hardship. Again, the property was platted in 1973. The primary structure was built in 1974, and the applicant's vesting deed has the property that they owned it in 2019. They haven't changed the primary structure as far as the structuring itself goes. Variance criteria 6, which is the last one, that allowing the variance will result in substantial justice being done, considering both the public benefit intended to be secured by this code and the individual hardships that will be suffered by a failure to grant the variance. Allowing the variance will allow the reasonable location of the accessory structure in a manner commonly enjoyed by others located within the same zoning district, as shown in that overhead of the property. The remaining setback is sufficient to ensure the structure will not substantially interfere with the rights of the abutting property owners. And that's to the rear and to the side, kind of western side yard. And the denial will disproportionately impact the setback of the property in comparison to other properties in the district. And then really quickly, the septic that is on the property is located behind the property, and it's going to be starting in a point that's between the southeastern point of the primary structure and the prefab garage. So we can't build on the septic, we can't build on top of it. So we have to pull away from that, which also further restricts our ability to place in other places within the property. And there's also large trees that the client maintains that also has a pretty substantial root system within the property.
Mr. Dion, can you show me on the site plan about where the septic tank is located, please?
Yes. Am I allowed to? Okay. So it starts here, approximately here. There's like a drainage pipe. And then there's drainage that goes all the way northeast to the other side of the property. And the actual septic tank is up here, but there is drainage all along here from the property.
Okay. And then that sort of dotted line towards the, I guess that would be the rear property boundary, that indicates, is that the setback?
So this dotted line here is a utility easement that's platted, and the larger dashes, that's the 25-foot rear setback.
Okay, great. That's all I need. Thank you.
Thank you.
All right.
I'm going to leave that.
And be sure and sign in with the clerk. All right, is there anyone here or online who wishes to speak in support of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, don't hear anyone. Development Services, anything further?
No, ma'am.
Okay. Applicant, did you have anything further? That's a no. All right. So this closes the hearing on variance 22-1669.
Madam Hearing Officer, the representative for the case that we deferred earlier in the hearing is now in the room.
Okay.
If you care to take up that one, or we'll proceed in order.
Yes, let's go back to that one, please.
Okay, so this will be item H2, variance application 22-1600. The applicant is Jenny Portes, requesting a variance to lot development standards. Staff findings were previously presented by Sam Ball.
Hello, my name is Carlos Castilla. I'm in 1936 West Martinez del King, Suite 205. I represent Mrs. Jenny. And sorry, I got this morning the zoning hearing, but it looks like it's the January 17. So my number is not there. I was here from 9:30 and I left. And anyway.
I'm sorry, could you clarify that? What said January 17th? It's right here, sir. What are you referring to, told you to be here on the 17th?
Oh, no, when I pick up this morning, I pick up the schedule for when I just noticed January 17.
Oh, all right.
So my number is not here.
I see.
So I left thinking it's no schedule.
That's not a hearing notice, is it?
Yes.
No, okay.
Zoning hearing master agenda, fine.
Okay, thank you.
And most of the time when I pick up, always is the one for the day.
Okay.
Not today. I don't understand why. And I'm trying to find the pictures for the, but I don't know how exactly that works.
Yes, it'll show up there, thank you.
Okay, that's the carport right there. The variance is for the setback right here, this one.
Please speak into the microphone.
Yeah.
I'm sorry.
There you go.
The variance is this part that you see here. That's the bill, the lady did a contract with somebody, I don't know exactly who, to build the carport. They told the lady they do it right, they do it everything, but looks like a no. And when we submit the drawings, we went there when the inspector, the code enforcement go to her house and say, hey, what is this? So she called us, we did the drawing, we did everything, and the setback supposed to be 25. They put it like a 20, I can't read it, sorry, I don't have my glasses. 20 something, That's why we're asking for the setback variance on the front from site plan. Sorry, that I'm a little mess because I was running here when they called me.
Well, let me just, if you don't mind, let me just ask you some questions.
Yes.
First of all, so the staff report says that according to the survey, the site plan.
The site plan,
All
yes.
right, so the site plan shows that the carport is set back 21 feet 2 inches.
Yes.
All right. And that the applicant is requesting a 5-foot decrease to the 25-foot required setback to allow a 20-foot setback. So is that accurate?
Yes,
Okay.
that's what I did. That's what we're asking for. Should be 21, but I was thinking with the probably overhead of the, we better ask for 20.
Okay.
Making in some parts of the county, the setback is 20, some is 25. That's why we just put 20.
And can you speak to any hardship that supports the variance request?
In the house, the lady who lived there is an old lady. Then she always got from the side of the house. So when it was raining, getting out of the car, getting in the house, so she finds somebody to do the carport. And they told her they do it right, they do everything for her to be easy to get from the car to the house. She's an old, I don't know how old is, but she's an old lady. That's the mother of the owner.
Okay. So she needs.
Of Jenny Portes.
I understand why a carport was needed then. Is there any reason why the carport could not have been set back 25 feet? Could it have been correctly located 25 feet?
I guess the people who build it, they know some places, a lot of places, the setback is 20. Probably they didn't find out that in that part is 25. That's why they delivered more than 20, but not 25.
Okay, so it was placed there, but you don't know of any reason why it could not have been placed at 25 feet setback?
Who built it, sorry, that's supposed to be, who built it, they probably, that's what I say, they probably thought the setback is 20. Okay. These people who build it everywhere around, and most of the time the setback is 20, City of Tampa and Hillsborough County and other counties, most of the time it's 20. So that's why they just make sure more than 20.
Okay.
But that part is 25.
Okay. All right, is there anything further you wish to add?
I guess.
Okay. All right, then that's all the questions I had for you. Please be sure and sign in with the clerk.
Yes.
Thank you. All right, is there anyone here or online who wishes to speak in support of this application? All right, do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, don't hear anyone. Development Services, anything further?
No, ma'am.
Okay. And applicant, one more time, did you have anything further? No. Okay, thank you. All right, we'll close the hearing then on variance 22-1600.
Our next case is item H6, variance application 22-1670. The applicant is Zule Garcia, requesting a variance to lot development standards and to accessory structure requirements. Staff findings will be presented by Tanya Chapela.
Good morning. This is Tanya Chapela, Development Services. The applicant requests multiple setback variances to accommodate an existing single-family house and 3 accessory structures on a corner lot zone RSC 6. The subject property fronts Twin Lakes Boulevard on the west side and abuts platted improvement right-of-way on the south side. Therefore, the parcel is a corner lot with required front yard setbacks on the west and south sides and required side yards on the east and north sides. Per the Land Development Code, Section 60101, the required minimum front yard setback for property zone RSC6 is 25 feet. The applicant requests a 6.98-foot reduction to the required front yard setback to allow a front setback of 18.02 feet from the south property line. In regards to the accessory structure on the north side of the house, per the Land Development Code, Section 61104C2, accessory structures that are 15 feet or less in height may occupy required side yards, provided that such structures are more distant from the street than any part of the principal building on the same lot and any lot abutting said required side yard. The subject shed is closer to Twin Lakes Boulevard than a portion of the house and therefore must meet principal building setbacks. Per the Land Development Code, Section 60101, the required minimum side yard setback for property zone RSC6 is 7.5 feet. The applicant requests a 5.25-foot reduction to the required side yard setback to allow a setback of 2.25 feet from the north property line. Now, the accessory structure at the northeast corner of the parcel, we have the Land Development Code, Section 1104C2. Accessory structures that are 15 feet or less in height may occupy required side yards, provided that such structures are more distant from the street than any part of the principal building on the same lot and any lot abutting said required side yard, provided, however, that such accessory structures are not no closer than 3 feet from the side lot line. So the applicant requests a 0.47-foot reduction to the required side setback to allow a setback of 2.53 feet from the north property line and a 0.67-foot reduction to the required side yard setback to allow a setback of 2.33 feet from the east property line. Finally, in regards to the accessory structure located at the southeast corner of the parcel, we'll be addressing Land Development Code Section 61104C1. Accessory structures that are 15 feet or less in height shall not be located in any required front yard except as otherwise provided in certain circumstances and shall not be located in required side yards. Per the Land Development Code, Section 61104C, accessory structures on corner lots shall be permitted to intrude up to 10 feet into the required front yard, functioning as a side yard. And as we said before, the front yard setback for property zone RSC6 is 25 feet. And the applicant is requesting a 10.99-foot reduction to the required front setback to allow a setback of 4.01 feet from the south property line and a 3.7-foot reduction to the required side yard setback to allow a setback of 3.8 feet from the east property line. With this, I conclude my presentation, unless you have any questions. Thank you.
I don't have any questions for you. Thank you. All right, applicant, please.
Hello, good morning.
Good
My
morning.
name is Zulay Garcia. My address is 86101 Twin Lake Boulevard, Tampa, Florida 33614. And I am here for variance, but I prefer my son speak with you. My English is not good.
Okay.
But thank you.
That's fine, thank you. We just need your name and address too, please, sir.
How you doing? Vincent Matos Garcia from 8601 Twin Lakes Boulevard, 33615. And I'll be translating for her.
Okay.
So everything she tells me in Spanish, I'll tell you in English.
Okay, thank you.
All right.
Okay.
Leo.
La razón que estamos aquí es por el variant que un vecino se quejó.
Well, we'll have her also speak into the microphone, please. And then you can translate her for her also in the microphone.
Okay,
Thank you.
Thank you. La razón que estamos aquí es por un vecino de nosotros se quejó por un carpo que hicimos en el patio y nosotros no sabemos por qué, porque lo hicimos con las medidas que tenemos que hacerlo. So, él dice que le molesta, pero nosotros lo hicimos solamente son 3 pies, nosotros lo hicimos, I'm sorry, en 5 pies de separación. Y la razón que compramos esa propiedad es porque mi esposo y yo llevamos más de 14 años trabajando construcción, pintura, cerca, chapeadura, y la compramos porque tenía un patio bien grande y podíamos poner esas casas para storage, y tenemos fotos de todo lo que tenemos adentro, pintura y cosas de albañilería. Solamente por eso compramos la propiedad. Y entonces queremos saber si podemos tenerla o no. Hicimos todo lo que nos mandaron y estamos aquí para que ustedes nos ayuden. Gracias.
Thank you.
All right. She said that we're here because neighbors. We had a complaint that neighbors said that we have 3 storages and they did not fit up to requirement because they were over 150 feet. And we checked them and measured them, and they were not over 150 feet. They said they had to be 3 feet away from the fence, and they are 5 feet away from the fence. They're all up to requirement, and we would like to see if, because we work like handyman and construction and gardening, so we have them all so we could keep everything inside of them. We have a lot of stuff, and that's why we have so many. And we just want to see if you can grant us that.
Okay. Just one moment. Let me see if I have any questions for you. When did you acquire the property? When did you?
Cuando fue que compramos la propiedad?
En junio.
Say it in. She needs to answer into the microphone, please.
Okay. Fue en junio del 2022.
Okay.
It was June of 2022.
Okay. And when you acquired the property, were those structures already in place? Were they there?
They were, except for one. We just put it next to it and we united them, and that's why they said that it was over 150 feet and we had to take them down, but we measured them and they did not pass 150 feet.
And which one was that, please?
I have a picture of them. It's I could probably put it right here. That one.
Tenemos fotos de dentro.
¿Cuál es este?
Esto es lo que tenemos adentro. Lo que tenemos adentro de aquí.
That's the one closest to the fence.
All right. So your property, your house, I guess, faces Twin Lakes Boulevard. Is that correct?
Yes.
Okay. So if you were standing in your front door looking out at Twin Lakes Boulevard, would this be the structure on your right or on your left?
On my left.
Okay. So this was on the left and toward the back of the house, correct?
Correct.
Okay. That's this structure in this picture.
Yes, ma'am.
Okay. So so something was there, but you brought something else in and added to it. Is that correct?
That is correct.
Okay. Thank you. Were the others, the other 2, I guess, were they there when you acquired the property?
Yes. Yes, they were there. This one is the only one that we added, and we added that right section.
Okay. Can you show me that picture? Yeah, thank you. All right. You added this section that has the door and the window, or the other part?
The other part.
Okay. All right. Can these structures be moved?
Yes, they can.
Okay. So could you move them on your property so that they were correctly situated away from the setback?
We could have. We didn't have a need to because they were up to requirements with the measurements, but we could also move them more if needed to.
Okay, according to the staff report, and I guess based on your survey, they don't meet the setback requirements. Do you understand what I mean by setback requirement?
That we had to move them.
Well, I'm just asking you, the distance away from your property boundary, they're not far enough away. That's why you need the variance, is that correct?
I understand, ma'am. My question is, they said it had to be 3 feet away from the fence, and they're 5 feet away from the fence, so they're more than far away.
All right, is it your testimony that all of the structures are 5 feet away from the fence at least?
Yes, all of ours.
Can you ask your mother to speak to that, please?
Dice que sí, este testimonio que está a 5 pies de la pared.
Sí, una está a 3 pies de la cerca y la otra está a 5 pies de la cerca.
She said one is 3 feet away and the other one is 5 feet away.
Okay. So apparently, according to the survey that you submitted, that's not quite accurate. So she might be mismeasuring or something.
Dice que el survey que tú hiciste no está bien eso.
¿El plano?
Ajá. Que dice que están a otra medida.
A 3 pies, ¿no?
Dice que no.
Nosotros mandamos a hacer el plano porque nos dijeron que teníamos que hacer un plano nuevo y el arquitecto fue y midió, dice que como estaba a 5 pies, él iba a poner correctamente que a 3 pies porque a 5 pies no había problema. Y entonces hizo los planos a 3 pies como tiene que ser, pero él dice que como estaba más de 3 pies, estaba bien. Eso fue lo que nos dijo. No sé.
Okay.
She said she was told to take out new blueprints, and when they took them, they said that they wrote everything that it was correct because everything was up to the requirements.
Okay. Okay. I don't have any further questions for you. Anything else you would like to add?
No, that's fine.
No, it's fine.
Thank you so much. Please be sure and sign in with the clerk.
Thank you.
Okay, thank you.
Thank you. All right, is there any, yes? Do you need development services? Thank you.
Tanya Chapela, Development Services. Just wanted to add a piece of information. So the the setback requirements are to the property line, and the applicant is referring to the fence, which in case of the accessory structure or shed located to the northwest of the property, the fence is not exactly right along the property line. So that may be a reason on this difference of numbers. Just wanted to add that to the conversation. Thank you.
All right, thank you, Ms. Chapela.
And also, Madam Hearing Master, I'd like to advise the applicants that
Okay, just a moment.
wait well until they're, however, with regards to the staff report and the setbacks that are in there, when you read that, although there are some circumstances where an accessory structure 15 feet or less in height is allowed a 3-foot setback, that doesn't apply to 2 of these for the reasons that are explained in the report. And so the report is accurate with regards to required setbacks. And then when they finish signing in, I do want to alert them to something.
Okay, thank you. Could the applicant come back to the microphone, please?
Right. Yeah, I just want to let you know that with regards to that 150 square foot footprint that you had referenced before, that is determines as to whether or not you need a building permit for a shed. It doesn't determine the setbacks. No matter how small a shed might be, you still are subject to required setbacks. And for 2 of your sheds, the setback that's required is not 3 feet for the reasons that are explained in the report. One of the sheds, the one that's at the rear corner of your property, the smallest shed, that is allowed a 3-foot setback, but it's actually less than that. So the setback requirement for 2 of the sheds was not 3 feet, even though they're less than 15. Now, if the variance is approved, any of the sheds that are more than 150 square feet in size, you're going to have to obtain building permits for those sheds. So the variance alone doesn't end the process. Okay? And
Yes, sir.
do you understand?
Yes, sir.
Okay, thank you.
Thank you.
Thank you.
All right, is there anyone here or online who wishes to speak in support of this variance request? All right, do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this variance request?
We have Sharon Cross.
All right, is that someone online?
They are online.
Okay, thank you. We have someone here in the lobby, and or in the room. We're going to let this witness speak first, and then we'll go to the online person. Thank you.
Good morning. It's still morning, Madam Hearing Officer. Alita McMillan, 8606 Villa Square Court, 33614 in Tampa. Located to the rear of the subject property. The concern is for the part of the variance with regard to the accessory structures. Note that it's not 1, not 2, but 3 accessory structures, all of which encroach significantly in either the front, side, and most significantly the rear property lines. I would also co-sign that the fence line may not be the property line, so that might contribute to some of that confusion. An example of the extreme encroachment in the setbacks, one is for 2.25 feet from one of the side lines. These structures are built right up to the property line, and I would note for the record the applicant's testimony with regard to handyman construction and gardening, which is a use that is inconsistent with the residential nature of the lot and the surrounding property. That use isn't incidental or subordinate to the primary use for the principal structure, which is residential. Based on the size, scale, and number of accessory structures, I request that this variance be denied.
All right, Ms. McMillan, just let me see, your property, you said you're to the rear. Are you just just to the east of this subject property?
I would, let me see.
And
If
your
it borders on the west, right, of Twin Lakes, I would be to the east.
Okay, so your backyard abuts the subject property's backyard.
Correct.
And one of the accessory structures then appears to be fairly close to your property boundary, is that correct?
Correct.
Okay. How long has that structure been there, to your knowledge anyway?
I just recently purchased my property, so unknown to me, unknown to me.
Okay, so it was there when you purchased your property, is that correct?
Correct.
Okay. All right. Thank you. All right, is there anyone else here in the room who wishes to speak in opposition? All right, don't hear anyone. Is there, there's someone online, I believe. We'll go online then, please.
Yes, Sharon Cross. I live at 8608 Villa Square Court, Tampa, Florida, 33614. I am on the east side of the property that is being mentioned. The owners, when they first moved in June and July, they proceeded to take and remove a tremendous number of trees that were there, including live oak trees. They said they had a permit. They did not say how many trees could be removed from that permit, but they removed a tremendous number of trees from the back and the front of their property. That barn has been there for at least 2 months that I am aware of. And I would like to state that the survey that they have presented is not correct. The very large structure, which is shown in the southeast corner of the property, is not in the southeast corner. It is in the northeast corner, which is directly next to my property. And it is very obvious. It is more, I believe, than 15 feet high. They do not have a permit for it. And I would like to state that the fence that they have used as the property line is not on their property line, it is on my property. And therefore, they are even closer to the property line of their own if they are not already on my property, which they may be. I haven't specifically measured it. The fence is not, I mean, the big barn that they have is there, and it does not show as yellow. It is a very, very large red barn, bright red, that is there. And I know that they have more than just the other 2 small sheds that they have indicated in that backyard. They have a multitude of them. I don't know the exact number, but I have seen, I would say, at least 5 of them that are there, unless they have been removed recently. I saw them, it was over a month ago. I have lived here for 3.5 years, and they have literally ruined the view from my backyard. And the eyesore that is currently there was built and is being used as a business, which I do not believe that they are licensed to build that barn, nor do I believe that they are allowed to do business of the sort that they are doing on that property. And I therefore object to this variance and wish it not to go through. Thank you.
All right, Ms. Cross, how long did you say you have owned your property?
I have owned it 3.5 years.
And when you bought your property, were there sheds on this subject property when you bought your property?
Not that I could see any.
Okay. So since you've owned your property, how many sheds have you seen erected on the subject property?
The smaller sheds that are probably only 6 feet tall, I have seen, I believe, about 4 or 5. It's only when I've gone by driving on Twin Lakes and the gate was open, that I saw that there was 2 additional red barns and then a few of the older barns, sheds that were there. The huge shed that they have built, which I believe needed a permit to be built to begin with, that is the only really very, very large and eyesore shed that's there now.
And what color is it, you said?
Bright red with a green trim.
Okay. And that, you believe, was recently built?
Yes, that was built, I'd say, approximately 2 to 3 months ago.
Okay, thank you. Anything further?
No, thank you.
All right. Is there anyone else here or online who wishes to speak in opposition to this variance request? All right, I don't hear anyone. Development Services, anything further?
Just want to state that in our review of variances, we really need to rely on the surveys that are submitted. Also, in this case, looking at the site in an aerial photograph, appears there's a lot of tree coverage in the backyard. So, however, it is the obligation of the applicant to submit accurate information and to request all variances that are needed. And if there are, in fact, structures that are on the property that are not shown on this site plan and need a variance, then the applicant would be required to, in the future, come back for another variance, or remove the structure, or move it. So anything that might be on the site and is not covered by this variance would still be in violation of the code if it doesn't meet required setbacks, et cetera.
Okay. Thank you, Mr. Hisney. Applicant, could you please come back to the microphone? Thank you. All right. Just first of all, I want to make clear that the variance request before me is what I will consider. So there are 3 variance requests for setback, and we've heard testimony today from your neighbors that there might be additional structures, but I'm not considering variances for those structures. If they are inappropriately placed into the setback or something, they may require variances as well. So you need to consider that. I'm considering the variances that are in this variance request before me today. And you heard the neighbor's testimony. Is there anything you want to say in rebuttal or summation or in response to that? Or anything else you want to put on the record?
Algo más quieras decir.
Yo no entendí bien lo que ella dijo, pero ella dijo algo de que yo tenía 3 casas en el patio.
Sí. Dilo que decir.
Bueno, yo no entendí bien lo que dijo la vecina, pero ella dijo que yo tenía negocio en mi patio, algo de eso dijo. Yo no lo creo, yo tengo... Esa casa que estaba ahí, la grande que estaba cuando nosotros compramos la propiedad y está en el plano. O sea, está en el plano, está todo bien legal desde que yo compré la casa. Las otras eran 2 y nosotros las ligamos, las juntamos. Por eso que están ahora esas 3 casas. Pero siempre han estado esas tres campos. Y lo que tenemos adentro, bueno, yo traje todas las fotos, pueden testificarlo, pueden ir a verlo. Es todo materiales de construcción. No sé a qué ella se refirió, pero yo estoy aquí diciendo solamente la verdad y pueden comprobarlo si quieren. Gracias.
All right. She said that well, first of all, she has a permit for the big one. She called a barn. And these other 2 small ones, they were already there when we bought the house. The only thing we did was put them together. I showed the picture of that. I also have pictures of all the insides of all of them, so you can see all we have is like paint and stuff inside all of them and storage. We're not doing any other business in that. We just use these as storage. As you can see, they're pretty packed up. Ella dijo que habían 2 nomás, ¿verdad? ¿O 3? 3. Yeah, and there are not 4 or 5 storage houses. There are only the one we talked about, which was on the left side, the big one, which is for the trailers, and the smaller one on the right, which we have all variants for all 3 of those, which is why we're here. The big one is not on her property line. It is on our property line. We already measured it. We already had the person go out there and measure it, and that's why he redid the papers, and he said they were correct. I'm not sure what she was referring to when she said we're doing business there, but as you can see from all these pictures, they're all just storages.
Just storage, okay.
Yeah.
All right. Thank you. All right, anything further?
That would be all.
All right. Thank you so much.
Thank you.
This will close the hearing on variance 22-1670.
And that concludes the variance requests. We have 1 special use case today. That is item J1, application number 22-1584. The applicant is Sandra and David Kennedy and Fernando Trejo. The request is for a 2 APS-IS alcoholic beverage permit with separation waivers. Staff report and recommendation will be presented by Tim Lampkin following the applicant's presentation.
Thank you. Applicant?
Good morning, Madam Hearing Officer. Joe Moretta for the record, 400 North Ashley with Gardner, Brewer, and Hudson. Madam Hearing Officer, we're here to present Special Use 2 APS-IS, which is being reviewed as a Special Use AB 22-1584. On the overhead, I would like to walk everyone
Make
through
sure the microphone's there with you too, please.
Can you hear?
Yes,
Thank you. Thank you for reminding me. I'll refer to the overhead for most of the presentation, and I would like to speak a little bit about the site details and the request. The site is located at the northeast corner of the Big Bend and Balm River View Road. This is Balm River View. Big Bend is located to the south. It's comprised of 2 parcels totaling about 1.80 acres. The 7-Eleven convenience store will be the host use. The request is for a 2 APS-IS that is seeking to allow package sales of beer and wine, which is incidental to the host use. The wet zoning area is approximately 4,825 feet. The 25% of the retail area will be limited, however, of that square footage because of the IS requirement. And the total area where they can use within that structure of the floor area will be 1,206 square feet. The host use will be constructed as part of an approved PD site plan. It's located obviously the same intersection, has gasoline canopies fronting along Balm Riverview Road, has access to Big Bend Road and also to Gordon Road, which is located to the east. The parcel itself is surrounded by 3 roadways. As I noted previously, this is a special use request. Special uses, when they're reviewed for alcohol, are reviewed, in addition to the zoning district permissibility, are allowed for separation waivers. In this particular case, the application would otherwise be approved administratively if not, except for the 500-foot separation requirement that is not meet from the school. As you know, that measurement is taken from the legal description of the wet zoning to the property line of the school. We're requesting a 256-foot reduction to the required 500-foot separation distance to allow separation of 244 feet. The school building itself, I would note, is located approximately 470 feet away from the legally described area. In terms of the waiver justification itself, in terms of the separation that exists and the features in the vicinity that would offset potentially that separation requirement. Balm Riverview Road is a very highly traveled roadway, a major roadway with a road right-of-way of 109 feet of width. The school ingress itself, the school access and egress is located and oriented along Big Bend Road towards the south. So the school access in front door basically looks to the south. Our use is located to the east of the site across Big Bend Road. So the school has a orientation for its ingress and egress totally facing away from the proposed site. The walking distance itself from the actual front door of the school to the property line of where our building will be housed is 579 feet. You would note, however, that in the staff report, the staff provided an actual walking distance from the front door to the actually legally described area, which is 760 feet. So those both exceed the 500 foot, which is required for separation, which is a more, in our view, refined metric than the blunt instrument of the 500 feet. There's a significant stormwater retention area that is on the front edge of the school along Balm Riverview, in between the actual site, just to the west of Balm Riverview Road, and that area of the school is also fenced. it's very unlikely that there's going to be any student activity in that area. In a drive-by inspection of the site, I also noticed that there's significant underlying brush growing there, and there's also trees planted. All that together serves to screen the site away from where the proposed area will be. Additionally, for the waiver justification, the host use, as I mentioned, will be 7-Eleven. 7-Eleven adheres to the requirements of alcohol licensing, Florida Statute 561.705, which is basically requires the vendor to provide a course of instruction to its employees, post signs on the premises informing customers of vendor policy against serving alcoholic beverages to underage persons. In the unlikely event that a youngster will make its way to the 7-Eleven, their staff is fully trained and capable of handling that type of event. So, getting to the recommendation, we believe that the application is consistent with the waiver provisions, which anticipate this type of separation, intervention, and also looks to travel distances that would, override a blunt instrument of just applying 500 feet. So as I noted before, from property line to where the access is, 579 feet. Staff will tell you when they, or assume they'll tell you when they read their report, 760 feet if you walk there from doorway to doorway. Staff has also found this approvable. We are available if you have any questions or comments. Thank you very much for allowing the presentation.
All right.
Appreciate
Thank you, Mr. Moreta.
Thank you.
Development Services.
Hello, Tim Lampkin, Development Services.
All right, bring the microphone over to you. Thank you.
Sorry, thank you. Tim Lampkin, Development Services. The request is for a distance separation waiver for 2 APS-IS AV permit for the incidental sale of beer in sealed containers only for consumption off the permitted premises in connection with a convenience store. In such case, the retail display of the beer and wine, including refrigerated displays, shall occupy no more than 25% of the establishment's gross floor area. The wet zoning is sought for 7-Eleven, located at 13009 Gordon Road, Riverview, Florida. The wet zoned area will comprise a footprint of 4,925.33 square feet of indoor area shown on the wet zone survey submitted January the 5th. Per land development section 6.11.11.d.5, the following distance requirements apply. The distance from the proposed structure to the school shall be 500 feet, and this application does not comply. The applicant requests a 256-foot reduction to the required separation from a residentially zoned property, from the school to the west of the subject site. The applicant has provided a justification detailed in their application and summarized in the staff report. Staff finds that pursuant to section 6.11.11.e.3, which provides for the approval of separation waivers where there are special or unique circumstances where the alcoholic beverage use applied for does not have significant impacts on surrounding land uses and certain circumstances negate the necessity for specified distance requirements. And further, staff finds that the proposed wet zoning is approximately 244 feet from the proposed wet zoning to Summerfield Elementary School. Staff notes that the school has a vegetated screening, as the applicant stated, and a fence surrounding the property at that location, creating a visual screening from the proposed wet zoning. Staff also notes that vehicular traffic exiting eastbound onto Big Bend Road from the proposed AV location is approximately 760 feet from the Summerfield Elementary School drop-off pickup area. Safe pedestrian travel from the proposed wet zoning to the Summerfield Elementary School roundabout drop-off pickup area requires walking approximately 760 feet due to the fence and vegetative area located on that quadrant of the school. School district staff objects to the proposed wet zoning on the grounds that it does not meet the separation requirements from the school. However, school staff does object to all requested separation waivers from schools and provides no basis for the objection other than the lack of the required separation. In the subject case, staff does find the circumstances discussed above mitigate the need for the required distance separation, and for the reasons staff finds the proposed wet zoning approvable. Staff finds the proposed 2 APS-IS alcoholic beverage permit to be approvable. Approvals based upon the revised wet zone survey reflecting a total wet zone footprint of 4,925 feet, 0.33 square feet, as shown on the wet zone survey received January 5th, 2023. And that concludes staff's presentation, unless there are any questions.
Just one quick little clarification.
Yes.
Mr. Lampkin, on page 2 of the staff report, there's just, it looks like actually a paragraph header that says required separation from residentially zoned property. Do you see that?
I do see that.
But there's no requirement.
There is,
Okay.
thank you for pointing
This is
that
just, yeah, just a waiver for from the school, distance waiver for the school.
out. That is correct.
Okay, thank you so much for clarifying that.
Thank you.
Uh-huh. All right, is there anyone here or online who wishes to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application?
There are 2 online to speak in opposition.
Okay. We'll hear from those online then, please.
Good afternoon. This is Buddy Harwell, 13802 Sweat Loop Road, Waimama, Florida, 33598. Vice President, Baum Civic Association, President of the Concerned Citizens of Gibsonton. We ask that you deny this request. Basically, for the distance waiver separation, the county has these rules and regulations in place for a reason. Seems like the convenience stores keep coming and asking for variance after variance. When you know the safety of our children are at current here, the 256-foot reduction. Want to mention the paper they had up there showing the walkable version of it. I want to point out that anytime that a zoning comes to the county, that they go from border to border, not from doorway to doorway, so this should be conceived the same. We'll have children walking by this store all the time from the neighborhood behind it. We know there's not supposed to be any drinking outside, but there is. How many times have you pulled up at a convenience store and find people drinking outside? So that's just, there's 4 other gas stations within a mile of this. We don't need one on this corner. We have 10,000 other corners that this would be more appropriate than across the street from an elementary school. The kids have enough problems without dealing with passing by this convenience stores and having people confronting them or whatever. I submitted in the ZHM and the VOCC that convenience stores are 4th on the list for violent crimes. Gas station is 7th on the list for violent crimes, and the possibility of fires also. Like I say, I just hope that you think this through, and let's set a precedent here, denying this. There's enough, like I say, other places that this would be more appropriate than the school. The school actually requested deny this, so that right there should be enough for deny. I have Jamie Franklin next to me that has signed up to speak also, and I'll pass the headset to him.
Well, hopefully this will work. Can anybody hear me?
Yes, we can hear you. State your...
Good deal. I'm with Mr. Harwell here. I really resist.
I'm sorry, state your name for the record, please.
Convenience store. Go what?
Yeah, name and address for the record, please.
My name is James Franklin. My address is 15064 Baum Road, downtown Baum, Florida.
Thank you. Go ahead.
All right, well, I'm with Mr. Harwell. I resist the kids walking by this convenience store where there's beer going to be sold and wine and cigarettes and probably vaping pens and everything else that the kids need to stay away from. I'm completely against it. I don't think we need it next to the school. And that's basically all I've got to say. Have a beautiful day.
Thank you, sir. All right, is there anyone else online or present in the room who wishes to speak in opposition to this application? All right, don't hear anyone. Going back to development services then.
No further comments unless you have questions.
Okay, no questions for you. Applicant?
Thank you. Madam Hearing Officer, I would just point out that the waiver provision, as I'm sure you're well aware of, specifically talks about where proposed structures are located in a manner that they, the normal route of travel between the proposed alcoholic beverage use and the resident and the community use would exceed the required separation distance. The 500 feet, as you know, it's a blunt instrument. There may be circumstances where an administrative approval could, wind up having a building that actually has the access and entrance closer to a use if designed differently. For example, if this building were to be put at maybe 530 feet, it was oriented to Baum Riverview, even though it would be an administrative approval, it could end up in a circumstance where the building access is actually closer. So we believe the metric that's being used both in the staff report and in the waiver provision that we've provided is a much more refined metric, fits squarely within the waiver provision, and we feel that that standard has been met. In terms of anyone that is loitering on the site, 7-Eleven is one of the premier names in convenience retailing. They have over 13,000 stores in the U.S. and Canada. They're well versed in terms of how to deal with anyone that might be loitering on their site. It's not in their best interest to even allow this to happen. And as we've said before, they're well trained and required by the state to train their employees in terms of being responsible vendors. So we believe that this case has merit, and we hope you will see it that way as well. Thank you very much for allowing us to make this presentation and also rebut. Thank you.
Thank you, sir. All right, this will close the hearing on Special Use 22-1584. And that concludes the Land Use Hearing Officer meeting for today. Thank you.